In this video, I'm going to provide a brief overview of the High Court's decision in Roadshow Films and iiNet. This decision was handed down in 2012, and it is now our most recent and our highest authority on authorisation liability in Australia. So, the facts of this case were that the Australian Federation Against Copyright Theft, AFACT, represented a number of large movie studios, most of the big ones from Hollywood. And they brought action against iiNet, which at the time of the judgment was Australia's third largest ISP, alleging that iiNet had authorised the copyright infringement of its users. Now, previous to bringing the case, AFACT had hired a company, a software company, to basically gather evidence over BitTorrent of iiNet users who were using BitTorrent to share movie files. So this company gathered evidence of the IP addresses of iiNet customers who were using BitTorrent, and then over a period of about a year, AFACT sent notices to iiNet every week with a list of IP addresses and allegations that the users at these IP addresses were infringing copyright by sharing movies and TV programs over BitTorrent. And they wanted iiNet to do something about it. Specifically, they referred to the agreement that iiNet had in place with its users when users signed up with iiNet to get internet access. That agreement was called the Customer Relation Agreement, and it contained certain provisions such as that users were not to break the law using the internet provided by iiNet, that they were not to infringe copyright, and that iiNet had the right to terminate the agreement for any breaches, including if the customers had done anything to break the law. So AFACT referred to these provisions of the CRA and said that iiNet has the power to do something in response to this evidence that they had provided that users were breaking the law, and what they really wanted iiNet to do was to rely on those provisions in the contract to terminate the contract, i.e. disconnect those users from the internet. So they sent these allegations along to iiNet every week, and iiNet did not do anything about them. iiNet raised certain objections. They said that the AFACT notices were hard to understand, the data was not very clear. They also pointed out that IP addresses only identify a particular computer, not the actual user at that IP address. And they said that this was a matter for the police, not for them. So they wanted AFACT to contact law enforcement and deal with it that way. iiNet's opinion was that it wasn't really any of their business. So they did nothing in response to the AFACT notices, and AFACT then brought a court case against them, saying that by doing nothing, iiNet was essentially approving all of these infringements and were authorising infringements. The provision that they really relied on was the word countenance. So you may recall from an earlier video, I said that authorise has been defined in Australian law to mean sanction, approve, countenance. And they relied on countenance, and they said that by doing nothing, iiNet countenanced infringement and therefore authorised infringement. So they brought the action to the Federal Court of Australia, which ruled in iiNet's favour. They appealed to the full Federal Court, and iiNet again won the case. And then finally, we reached the High Court on appeal. Now, the High Court handed down two judgments, one by Chief Justice French and Justices Crennan and Kiefel, and another by Justices Gummow and Hayne. And I will go through each in turn. The important point, though, is that the decision was unanimous. All judges found for iiNet. So, the French judgment Firstly, they were critical of AFAC's reliance on countenancing to try to argue that IINet had authorised infringement. They said that the meaning of countenance is not always coextensive with the meaning of authorise. So they do not always mean the exact same thing, and it was wrong of AFAC to rely on the meaning of countenance, which was a little bit broader than authorise, and to say that this meant that IINet had broken copyright law. They then turned to the factors that they are required to consider in the Copyright Act, set out for the purposes of this case in section 101(1)(a). And the first factor that they had to look at was IINet's power to prevent infringement. And the Chief Justice French and Justices Crennan and Kiefel held that IINet only had an indirect power to prevent infringement through terminating the contract. So IINet had no actual control over what the users did on the internet. They had no control over BitTorrent. They had nothing to do with BitTorrent. The only control or power that they had to prevent infringement was through these provisions of the contract, which gave them the power to terminate the contract. And the judges held that this was not enough. This was too far removed, it was limited, it was indirect, it was not enough to satisfy the requirements under the Copyright Act for authorisation. The judges didn't give too much consideration to the second element, the relationship between IINet and their users, except in discussion through about the contract provisions. But in terms of the third factor, whether IINet could take any reasonable steps to prevent or avoid infringement, they held that terminating the contract, again, disconnecting people from the internet, was not a reasonable step. It was not a proportional step to take in response to the allegations received from AFAC in the form of those weekly notices. The French judgment considered that IINet's inactivity was not a result of indifference or them not caring about the infringement that happened, but was rather a risk assessment on IINet's part. So IINet would have put itself at risk by terminating contracts. And that risk was wrongful termination. They might have then been sued by users for wrongful termination if they terminated contracts on the basis of AFAC notices, because there was no way for IINet to know whether the information contained in the AFAC notices was true or not, and therefore they didn't want to take the risk of terminating contracts on the strength of that information. So that was what the French judgment concluded, that it was perfectly reasonable for IINet to do nothing in the circumstances. So they dismissed the appeal and they held for IINet. And they concluded that the appellant's submission that IINet should be taken to have authorised the infringements unless it took measures with respect to its customers assumes obligations on the part of an ISP which the Copyright Act just does not impose. So that was the French judgment. The other judgment was that delivered by Justices Gummow and Hain. And they firstly made similar statements about the appellant's reliance on the word countenance. They said, it would be wrong to take from the definition of authorise one element, such as countenance, and by fixing upon the broadest dictionary meaning of the word, seek to expand the core notion of authorise. And their honours were rather critical in general of the fact that we define authorise by reference to dictionary synonyms. And they said you can't take the broadest meaning of the broadest word and by doing that seek to essentially lower the standard for authorization by pushing it ever outwards in terms of what will be caught as authorizing behaviour. They then turned to the factors in section 101(1)(a), And again, in terms of power to prevent, they held that IINet's only power was the power to terminate the contract, which was limited and indirect and not enough. In terms of reasonable steps, their honours looked at the fact that AFAC had said that IINet might have sent warning notices to their customers and that this might be a reasonable step that IINet could have taken instead of terminating the contracts. And Justices Gummow and Haynes said maybe warning notices would be a reasonable step, except for two things. Firstly, the AFAC notices were faulty. There was some missing information, the information was not clear, and so you couldn't expect IINet to send warning notices on the basis of the AFAC notices, which themselves were faulty. The second thing is that we don't really know if warning notices sent to customers would be effective. We don't know how customers would respond to the warning notices, whether that would make them stop infringing. So maybe it would be a reasonable step, but probably not in the circumstances of this case. They thought that really, even though AFAC was talking about warning notices, really the only reasonable step that IINet could take was to exercise its powers under the contract to terminate agreements and disconnect users from the internet. And for the same reasons as in the French judgment, they said that this was not an appropriate step. This was not a reasonable step for IINet to take. It went well beyond what could be expected of an ISP. So they also held that there was no authorisation, and they found in IINet's favour. And they concluded that the progression urged by the appellants from the evidence to indifference, to countenancing, and so to authorisation is too long a march. So they thought really that the appellants were really stretching the law here. They were clutching at straws. They were trying to push the law to its outermost boundaries in order to catch the ISP, and this was just not going to happen in this case. It was not an appropriate thing to do. So, the consequences of this case, what are its implications? Obviously, the tech industry was very happy. This decision now means that without doing more, without being more involved in infringement, an ISP that simply provides internet access will not be held liable for authorisation in Australia. So this was a big win for ISPs. The content industry, it goes without saying, were not happy, but also the government was not happy. The Australian government was very concerned by this decision, mostly because they had been pushing the tech industry and the content industry for a number of years to come together and form some sort of industry agreement, sometimes called an industry protocol or a industry code of practice. Basically, they wanted to, instead of having to make legislative reform, they wanted a private ordering solution, that the ISPs and the content industry would cooperate to fight infringement by sending out warning notices or what are sometimes called education notices to their users. And the government was worried post-IINet because what it meant was that ISPs now had no incentive to cooperate. They had a High Court decision saying that they were not liable, and so why would they agree to send out notices or take any other measures if they did not face any legal liability? So the government, after this decision, then tried to look at other ways to compel ISPs to work with the content industry. One of the proposals they came up with was in 2014, the government released a discussion paper in which they proposed amendments to Section 36(1)(a) and 101(1)(a) of the Copyright Act. And what they wanted to do was remove power to prevent as a factor, a separate factor that courts must consider when determining authorization, and they wanted to subsume it with the reasonable steps factor. So when a court looked at the reasonable steps an intermediary might take, one of the things that might bear on that was how much power the intermediary had to prevent infringement, but it would not be a separate factor. And what this would have meant was that ISPs might be compelled to take certain reasonable steps even though they don't have a direct power to prevent infringement, even if their power was, as the High Court held in this case, limited and indirect. So that was the proposal. It was opposed in many submissions, and it ultimately fell over. The government never proceeded with that. There was never any law reform. And since then, discussions about industry protocols have stalled, and the government has moved on to looking at website blocking. And they've enacted a new provision of the Copyright Act, Section 115A, which allows courts to grant injunctions against ISPs to block certain websites that have infringing content. But I will talk more about that in a separate video. For now, though, that is the summary of Roadshow Films and iiNet.